Good morning, Ms. Winfield. It's sometimes difficult to hear who is speaking. As you may have been watching, the clerk will give you 10 minutes. When you have used up 9 minutes of your time, the orange light will come on, which means you've got 1 more minute. And when the red light begins to flash, you have to stop.
Good morning.
Good morning.
I must say that my name is Mary Winfield, and I'm an appellant in this case. My husband, Robert Winfield, is here, but this year, events of this year have taken a big toll on him, so he will not be presiding, so I will use up the time. Today is D-Day, so we remember the people who fought and died to defend this country and our liberty and freedom, the invasion of Pearl Harbor by the Japanese. More than a privilege, it is a high honor for me to be before you today. 30 years ago, I traveled 2,500 miles in the pursuit of the American freedom, law and order, and justice. This case came before you on direct appellate review from single justice, and the case was denied, but there was no opinion issued, and my interpretation was of the paperwork that was sent out is that the justice believed at the time that we had not exhausted other avenues of appeal for relief. So we went back and did that. We exhausted those avenues, and they led us here. On January 23rd, 2009, Justice Shahagan of the Public Court issued an order authorizing police and sheriff deputies to come and remove us forcefully out of our rented apartment. We were there for only 2 weeks. We had just moved in, and I was sitting there. In fact, that was my first day out of bed I was sick with the flu. And I was just thinking I missed the inauguration ceremonies of President Obama because I was so sick that week. And the door, knock on the door, police and sheriff deputy told us we were trespassing, we had to move out right away. This was done under 19A, Chapter 19A. Chapter 19A has an emergency order for protection of elderly people. And the emergency is defined as a threat of physical harm or risk of physical harm to a person. Elder Services of Merrimack Valley presented an ex parte motion, an affidavit, and the emergency was created by Elder Services. And the emergency was that the elder living upstairs on the second floor, the sister of that lady who rented us the downstairs apartment, was at imminent risk of losing her home to us because from what they understood, we were swindlers of houses. That was the emergency. So they created something outside of 19A. Now, the question is not whether our substantive rights were violated. The question is how many of our rights were violated that day. Just a few examples. The Fourth Amendment of the Constitution of the United States on original search and seizure. The police forced us to walk out of the apartment. We get into our car not knowing where we were going. They locked all our things. They changed the lock. We left with absolutely nothing. They seized our things, and it was months before we could even go back to retrieve anything. If somebody had asked you to leave your house immediately, I don't know if you would know what to grab. Your partial, your denture, medicine, something that you really need urgently. We didn't have a chance to do that.
Well, the February 9th order of the second probate judge gave you the right to go retrieve your belongings, correct?
The February 9th, on February 9th, on an emergency basis, the judge then reissued that order because there was a provision in the original order for us to retrieve necessities, but the police did not let us read the order. They said, get out, read it later. Now, on February 9th, the judge reissued the order, but it took until April because there was confusion. It wasn't clear who had the key to the apartment, who was to let us in. So it took a couple more months before we could get in. And in addition to Amendment 4, MGL 239, Section 2, Forcible Entry into a Residence, Chapter 184, Section 18, 186, Section 11 and 14, the right to quiet enjoyment, the Massachusetts Uniform Summary Process Rule, the Massachusetts Rule of Civil Procedure 4C and D, as well as several articles of the Massachusetts Constitution were violated. Now, there are some salient points that I really need to get to. One is that on January 23rd, the services obtained this order on the grounds that we were going to swindle this house. But as early as February 2nd, in a hearing at the probate court and in paperwork to the single justice, they changed that ground to we had rented the house illegally because Lillian Chivoni did not have the right to rent us the house. The problem with that is that Lillian Chivoni is half owner of the house, had been renting the house since the 1970s, the apartment, because her sister lives upstairs, which really made that transaction a common law transaction. She's been doing it for almost 40 years. And she has power of attorney of her sister. So our lease agreement was legal. But most recently in their reply brief, attorney for all the services yet came up with a third reason why this January 23rd order happened, and that was that we were somehow exploiting the elder because we had borrowed money from her sister. And they tried to dissuade this court from granting relief by saying that there was a trial scheduled for November 3rd and 4th on the merits, and that there shouldn't be no appeal because we should wait for a trial on the merits. In July, in a pretrial memorandum, Counsel for Elder Services wrote as issues to be resolved. Was the January 23rd removing the Winfields out of the apartment justified? In other words, before I said that, on October 13th, Judge Emmy Blake sua ponte dismissed all actions against us because our services had included us in the guardianship, of Neddy Carpinoni. Judge Blake dismissed that. That's the trial counsel was talking about. So that was dismissed. Not only that, Judge Blake extended the time for us to keep our belongings in the apartment in order to give this court time to make a decision and apply remedy as necessary.
Is the case still pending in the probate and family court?
No, it's dismissed.
But then,
So, in other words, that's why we don't execute people in this country and then hold hearings to decide whether they were guilty or innocent
And it was dismissed when?
until October 13th.
And did you take? I'll ask counsel for Merrimack Valley.
So, what I would like to conclude with this court is that this order virtually has opened a floodgate, dangerous floodgate. And I really would like to ask this court to erect some barriers to this, because on January 23rd, it was our family, and soon it will be some other family. There are judges who give more scrutiny and take more pains issuing search and arrest warrants than Judge Shahagan took, throwing our whole family onto the street on a moment's notice, including children who are yet to learn how cold and cruel this world can really be.
Thank you, Ms. Winfield. Good morning, Mr. Schutzbank.
Good afternoon, Madam Chief Justice. May it please the court, for the record, Attorney Eric Schutzbank on behalf of the appellee, Elder Services of the Merrimack Valley. I had intended to rest on the brief filed, but there have been some factual inaccuracies stated, so that I am...
Is the case still pending?
The case is not pending, Your Honor, but there's some things I want to explain about that as to what Judge Blake did. Sua sponte, about a month before the trial, Judge Blake gave everyone notice to appear in probate court on October 13th. The judge explained that under her interpretation of Mass General Law, Chapter 19A, there was no longer a need for a trial involving Marie and Robert Winfield because the elder was protected. Mass General Law, Chapter 19A, as I'm sure the court is aware, is out for the protection of elders.
But assuming that there's some, I mean, can the Winfields take an appeal from that?
It's an interesting question, Your Honor. I don't believe from a dismissal they could take an appeal. However, there are two things I would remind the court. One, at the time their 211-3 petition was filed, the trial was still pending. So that is...
No, I understand.
How are they supposed to get relief?
They have... I'm sorry, Your Honor. I'll let you finish.
Well, they allege that through your petition under Chapter 19A, I take it Section 20, is that right?
That is correct, Your Honor.
Under that petition, you got the court to get them removed, and they think that they had a valid. I mean, they argue that they had a valid lease for that apartment, and they shouldn't have been removed. So how do they challenge that?
I will address several of the issues you've raised in that question, Your Honor. They have several means to challenge. They can actually file civil suit in the lower courts to sue either the court for their ruling or Elder Services. In fact, they have filed 2 civil suits already against Elder Services that have been dismissed for their failure to appear in court. They have currently pending a federal lawsuit against Elder Services in Merrimack Valley, although Elder Services and the social...
Are you telling me that if there's been a deprivation of of some kind, that the only way that these individuals can obtain relief is to sue the judge?
Potentially to sue the court, Your Honor, or actually to sue Elder Services for the actions we took.
Why? I mean, if the judge made an incorrect ruling, why do they have the burden of going to sue somebody? I mean, can't they appeal that in the regular course?
Appeal the dismissal?
I'm not certain, Your Honor. It's a
Why isn't it like any other lawsuit? It's a judgment of dismissal. It's a final judgment. And why isn't it appealable? Is there something in the law that says that it's not appealable?
There is nothing in the law that says that it's not appealable, Your Honors, and I suspect they could appeal the issue. In fact, there's really very
Why do you
limited
think they might
procedures.
not be able to appeal it?
Because I take it that the elder is now protected because they've been moved out, correct?
That's correct.
What did the judge inform them with respect to what potential avenues they had, if any?
Judge Blake did not inform them of any potential avenues. All she did was issue a judgment that said, this matter is dismissed at this time. The elder is no longer in need of these particular protective orders because she has a permanent guardian. And I would also state to the court that the judge found on the record.
Is she living in the house still?
The elder is still living in the house. The Winfields are actually living with her sister. And there was a trial against Ms. Schiavone that concluded last week, at which came in lots of evidence of financial exploitation involving the Winfields. And I would point out that they probably can appeal. It's a question on dismissal.
Excuse me, what is the status of that? The trial concluded, is it under advisement?
The day after Thanksgiving,
Is it under advisement?
We have until December 30th to file our findings of fact in the matter.
Is that in the probate court?
That is in the probate and family court. Technically 3 cases went to trial. The 19A petition against Ms. Schiavone and the guardianship and conservatorship petitions that we filed under 19A.
Mr. Schutzbank, one of the problems I have with your brief is it doesn't comply with the rules, and I don't have access to the statute as I'm sitting here. How do you respond to their claim that 19A addresses physical abuse? Is it broader than that?
It is much broader than that, Your Honor, and I apologize. Appellate work is not my forte if I did not comply with the rules. The statute is very clear. It encompasses the following. We can protect in order for physical abuse, emotional abuse, neglect, self-neglect, and financial exploitation.
Okay. So, as a general matter, are there any, I mean, when you were first before the single justice, did you in essence say these people don't have standing because we've now got a guardian and the case will be dismissed?
We did not raise the issue of their standing, Your Honor, because at that time the case was scheduled for trial as to whether permanent protective orders would be necessary under the statute.
So this is an order entered against the Winfields, correct?
Yes and no, I would say, Your Honor.
Well,
It's a specific order that they have to leave the house.
That is correct, but there were also orders that the lease was actually not valid. Prior to issuing the lease, Ms. Schiavone had been under orders by the probate court not to enter into any financial transactions involving any property owned by her sister due to the serious allegations of financial exploitation.
But there was a specific order for them to leave the house.
That is correct, Your Honor, and the sheriffs came in. They were there for approximately an hour. And I would point out, Your Honors, that over the last 9 months, there have been several orders for the Winfields to obtain their property. As a result of the Winfields not properly following those orders, not contacting the guardian appropriately, just showing up randomly at the police station, they did not retrieve all of their property. I will also report to the court that when I found out about this, I attempted to help because I thought they should have their property back.
There are two different things here. The first is, in what circumstances can somebody who has been ordered out of their residence, which they claim is pursuant to a valid lease, can they challenge an order, when the judge dismisses the case, can the judge do that? Because while it may be the case that the elder is now protected because the elder has a permanent guardian, I take it that's the basis of Judge Blake's order?
That is correct, Your Honor.
I'm not sure that you can just dismiss the case if the rights of the defendants have not been addressed.
I would point out, Your Honors, that at the time of the dismissal, the defendant, the Winfields, did not object to the dismissal of the case. They were present in the hearing when the case was dismissed. And I'd also suggest, as it was suggested by the court earlier, that this is like any other dismissal in a civil case. They probably can take the means to appeal through the normal appellate course, saying that the dismissal was improper without a final ruling on the validity of the lease.
Mr. Schutzbank, can I just say, the issue of the dismissal is not before us, is that correct?
That is correct.
I would ask that you file a letter, we can take judicial notice of a docket if you could bring, and then you obviously serve it on the Winfields. Could you make sure that we have the docket, and if you could submit that to the court, would 2 weeks be sufficient?
Absolutely, Your Honor.
Okay, if you can do it sooner than that, that would be helpful, but...
Your Honor, I will get myself to Salem this week to get the docket.
Okay, that would be very helpful, and just make sure that the clerk,
Absolutely.
and if there are any papers on file in connection with that? It would be helpful to have those. I suspect they're not. It sounds as if there was just a hearing.
Your Honor, there's a judgment on file,
Fine.
and there was also, I don't know if you want the Winfield's motion to stay the proceedings filed.
At the same hearing?
It was filed after that hearing and heard
Fine.
the day before the trial.
That would be helpful. And you will give copies, obviously serve copies on the Winfields.
Yes, Your Honor.
Thank you
Of course.
very much.
Just
I'm sorry, Justice
I have
Watson.
one question. The proceedings that you said just finished, that you have time to, are the Winfields parties to those?
They are not. They are not parties to that, and I would just wrap up in saying, Your Honors, that the single justice was fully within his discretion and did not err as a matter of law in denying to hear this brief, which I believe is the single issue before the court at this time. And I would ask that the court deny the appeal. Thank you.
Thank you, Mr. Schutzen.
All rise.